Welcome to another of METV's programs on legal topics affecting families and children. I'm Senior Judge Lee Hayworth. Today we're going to discuss how courts decide what used to be called child custody issues. It goes by a different name now, and we'll find out why in just a few minutes. When couples split, how do attorneys help their clients resolve the issues that affect their children? What do parents need to do regarding their children when faced with a family breaking up? Assuming they can agree, how do they go about making it official? When they don't agree, how do judges, judicial officers decide how much time the children should spend with each parent? Are there cases where one parent should have little or no contact with the child? These issues can generate the most heat between separating adults. They often overshadow the question of alimony and how to divide assets and liabilities. They're the most divisive and emotionally charged issues in a family law case. We will attempt to answer these questions. Florida law says the best interest of the child shall be the primary consideration. But how does one arrive at what is in a child's best interest? We will discuss the statutory scheme and how psychologists, lawyers, and judges struggle to arrive at the right results for the youngsters who are caught in the crossfire of their parents' domestic welfare. So let me introduce our panel of experts. I'm going to start with Ed Sobel. Ed, I'm going to give a brief outline for you. You're a certified family law attorney. You've been practicing for a number of years. You were cum laude undergraduate with a degree in psychology. No doubt that helps you out in that field.
Absolutely, Judge.
And then you graduated Emory Law. How many years have you been practicing, Ed?
I've been practicing over 35 years.
Okay, and that's all been mostly with family?
Yes, mostly family law, and I would say for the last 30 years, it's been exclusively family law.
All right. Seated next to you is Magistrate Renee Inman. Renee, you went to college out of state. You graduated New England School of Law, and you've worked for judges as a clerk in Massachusetts and Maine, and also the 12th Circuit.
That's correct.
And then when were you appointed as a magistrate?
I've been a magistrate since 2010, so I'm going on my 6th year.
All right. Just briefly, what's the difference between a magistrate and a judge?
Well, judges are elected officers. They're outlined in the Constitution, and so they are accountable to the people through the election process. Magistrates are appointed by the chief judge of our circuit, and we have much more limited authority than judges do. For example, we have to have the consent of the parties to hear a case, and anything that we decide, there is normally a 10-day exceptions or appeal period between the time that I issue a recommended order, for example, and the judge then signs that order, making it final. So anything I issue is not final until I get the judge's signature.
Okay, next to you is Dr. Brad Broder. Dr. Broder is a graduate of Hofstra University, where he got his PhD, and I have to say that he just received the Sarasota Child Protection Center's award for the 2016 Child Advocate of the Year, so congratulations on that.
Thank you, Your Honor.
So you also get appointments from judges, and you get hired by private folks to do recommendations and assessments of their parenting skills. How many cases do you say you've probably done in your career here in Sarasota or Manatee?
Well, first I started out in New York State, where I'm licensed. Worked there for 13 years before relocating here to Florida, and I probably end up with about 6 to 8 cases a year between the two counties, full court-oriented social investigations and parenting plans.
Great. Well, we'll get into those in just a few minutes. Now, there's two basic ways that child custody issues are decided. First, they are resolved by the agreement of the parties, frequently and advisedly with the benefit of an attorney on both sides helping them out. And then secondly, when they can't agree, it goes in front of a judge or a judicial officer such as Magistrate Inman, and they get a result they may not always like. And of course, from the judicial standpoint, we prefer people working it out. So Ed, I'm going to turn to you and ask you, first off, do you represent just the fathers or the mothers, or do you discriminate in that way at all?
No, we represent both. whoever contacts us first is usually the one we're going to be representing. We started with a consultation where the mother or father come to our office, and I have an interview with them. They interview me, I interview them. I get a picture of their family situation and find out what their goals are for the custody situation. And usually at that point, I'll go through the law with them so that they have a good understanding of what the framework is of what they're working with in the child custody matter.
Well, you know, before I became a judge, I did some family law practice. In those days, we talked about things like primary residential parents, secondary residential parents. We had things we talked about visitation in custody. Then there was a change in the law. Some of those other cases still might be around because some of those agreements, children not yet turned 18, but there was a change. What was the reasoning behind that change? Do you know?
Well, it's been an evolution in family law over the 30 years I've been practicing it. When I started doing it in the mid-'80s, mostly the women were going to have the children most of the week, and the fathers usually got the children for dinner on Wednesday or one evening during the week and over the weekends. I think as women became more a part of the workforce and became more empowered by becoming professionals and being in the legislature and matters like that, it freed up the men to be able to spend more time with the children. Starting in the late 80s, mediation started to come into use, and the parties would meet with mediators, and a lot of times to settle their issues, they often had common goals, and a lot of the women welcomed the ability to be able to work more hours and to be freed up from the overall child rearing responsibility. The law changed a few years ago. We went from what we used to have was primary physical residential responsibility was the term, and that was what most people would consider custody. That usually went with the women. When it went with a man, it was usually that there was some sort of defective situation in the mother's household. That primary physical parental responsibility was abolished by the legislature a few years ago. And I think it took the focus out of winning and losing and put the focus on sharing parental responsibility and making decisions jointly together, including what we call the time sharing, which used to be visitation, the time sharing schedule, when the children will be spending their time with each parent.
Well, let's talk about that because a lot of the folks who are trying to work through these issues do it without the benefit of a lawyer. And we can all see the mistakes that they've made and the problems that has caused down the road. And we'll get to that in just a moment. But the legislature adopted something called a parenting plan and a time-sharing arrangement. Let's talk first, what is a parenting plan?
Well, this is a parenting plan. There are several forms of this document. They're all about 23 pages. Most people use the basic parenting plan. That applies to the usual situation that we're dealing with in our courts. We also have a long-distance parenting plan, and what that's for is where one parent lives more than 50 miles away, usually out of state, and has provisions in it to help address the issues of people living far apart. There's other parenting plans for specific issues, but again, this is the one we mostly use. And the custody is now broken down into shared parental responsibility, that's joint decision making. We sometimes have sole parental responsibility where one parent makes all the decisions, but that's pretty rare. And that's when it is decided that it would be detrimental to the children for one of the parents to have to consult with the other parent for whatever the defect of that parent might be.
So you might have somebody that's alcoholic or a serious mental illness or perhaps abusing the children. those are the situations you would consider sole parental responsibility.
That is correct. And you have to make a specific finding in court that it is detrimental to share parental responsibility. But again, that is a small percentage of the cases. Most of the cases we're dealing with this basic parenting plan. And at our first meeting with our clients, we usually give them this plan. We ask them to take it home. We ask them to review it and fill it out the best that they can. We don't want them to get overwhelmed that it's 23 pages. It's mostly fill in the blank and check the appropriate block for your family.
I think the important thing about parenting plans is to know that you just don't pull out a form out of a drawer and use a cookie cutter approach. In other words, it has to be customized to the individual parents. And let's talk about some of the issues that would go into a parenting plan. For example, how do they work out, when school's coming up for a break or there's a holiday? How does that approached in the parenting plan?
Well, the parenting plan covers every known holiday, both for school, summer break, and religious. Something that's kind of comical in the profession is that some people think they have to fill out every blank in the form. So a good number of people will fill out the holidays for Christianity, Judaism, and for the Islam faith. And we usually ask, what are you? And why did you fill this out? And we tell them it's not unusual, people do it. But what the purpose of the parenting plan is so that people don't have to keep calling attorneys or worse, going to court. They can fill this out together or work out a joint plan and mediation. And then if issues come up in the future that they're not agreeable on, they can go look at the plan and say, how did we decide we're going to divide Christmas?
And I think if I may just piggyback on that, I think the main component of this parenting plan is specificity. We want to make sure to tailor it to the particular family's needs, but when the mom and dad can be very, very specific as to pickup times, drop-off times, exchange, place of exchange, whether they're allowed to bring their toys or clothes, etc. So the plan then outlines it, and as my esteemed colleague shared, they could always refer to it and make good on that for the best of the children.
I think the nice thing about the parenting plan is it makes the parents focus in on things they may not have ever considered. For example, extracurricular activities. Maybe the father wants the kid to play baseball, the mother wants them to play the piano, and they have to work through those issues and decide, how are we going to work together to make this happen? And also things like, communicating back and forth. Are they going to do it by phone, texting, emails? And when parents are in kind of a hostile relationship between themselves, it allows them to find ways to make the relationship between them work in a way that protects the kids. And I think that's a valuable asset also. So let me ask Ed about time sharing. What are some of the typical arrangements that parents come up with when they sit down and say, well, you're going to have the kids on these days and those days. What are the typical percentage breakdowns?
Well, I would tell you from my experience when we work these things out, it's not much different than when we go to court. What most of the time-sharing schedules come out with are between 40 and 60% for each parent. If one parent gets the children about 43% of the time, the other parent gets them 57% of the time. I've had people who have argued over their percentage of time who have told me after they were done arguing and actually living under the parenting plan that their existence could not tell the difference between 43 and 50% of the time with the children. When we are saying the percentage of time, the parenting plans are geared towards overnights. Overnights are what are counting the percentage of time that the children are with each parent. As far as what the people do on the breakup, in the basic parenting plan, there are several suggested time-sharing plans. They take a week, label it Monday through Sunday, and they have mom, dad, whoever gets the children on each day. The plans have different names. They sound like dance steps, a 772 plan, a 346 plan, whatever. But a lot of times you find that the parties, if they've already separated, already have kind of evolved into their own schedule, which meets their work schedules, the children's schedules, and any other obligations that any member of the family might have. But if they don't have one, that they're not sure what they want to do, we invite them to look at the different schedules, and they usually find one that matches their lifestyle, including one of the schedules in there matches the schedules for our first responders, the ones that work nights and days depending on whichever week it is. At least one of the schedules pretty much matches that, which clients will tell me, oh, I went through them and this one matches my work schedule exactly.
Well, one of the consequences of the percentage allocation between the parents, it can have effect on the child support. Is that right?
Yes. Child support calculations, which would be another TV show,
right,
do factor in the number of nights that each parent has the children.
And sometimes that's a point of conflict. Sometimes the parents, if it wasn't for that issue, they could come to an arrangement. Dr. Broder, you've probably seen something like that.
Yeah, certainly, and that's why we sometimes I'm called in to do an evaluation, because you're really trying to assess, are the parents, in many cases the dad, are they really focused on the child's needs and looking at the developmental stage for the child and what that child needs, or are they looking to reach that magical 40% so they can have their child support payments adjusted to some degree?
Well, I think this is a good segue to the situation that we face when parents don't agree, and that's when Magistrate Inman gets involved. And I'm going to ask you some questions about that. But,
Sure.
But let me give a couple of resources for our audience. The Florida Supreme Court has an excellent website that has these parenting plans accessible for anybody to look at and download and fill out. And there's also something that's a commercial product, and there's several of them out there. But the one that I have heard used frequently is something called Our Family Wizard. And it's ourfamilywizard.com, and apparently for a small amount of money, it's very useful for parents who have a contentious relationship and have difficulty coordinating things like the time sharing. I'll give you an example. A parent is supposed to pick a child up at 6 o'clock on Friday. Well, it turns out that the person has to work until 7 and can't pick up the child at 6. So the parent who has the child says, you missed your 6 o'clock, you're not getting the kid this weekend, or whatever. Well, Our Family Wizard allows the people to communicate between themselves by emails. It tracks all that, so you can see what they're saying to each other. And it's a way for them to try to resolve their issues without having to run to court every time there's a problem. So it's a useful tool. So I think the people watching might find that of interest, as well as the Supreme Court's website. So let's talk about the situation with litigation when it comes in front of you, Magistrate Inman. And I want to reiterate, it's much better for the parties to work things out between themselves, hopefully with the benefit of an attorney, because judges don't have as much insight into the problems and the issues of the family than the parents themselves are going to have. So when a magistrate or a judge makes a decision, they do the best they can, but it's not going to make everybody happy. And it's much better for the people to work their own arrangement out and come to the court with that already stipulated.
And before you get to the question, if you don't mind me just jumping in and just relaying some of my personal experience with, because I handle a lot of pro se people, pro se litigants, pro se meaning parties without attorneys. Now, you are certainly, anybody can certainly come to court and represent themselves, but family law can be very complicated, and it's always better to, or certainly advisable to have an attorney with you. Nevertheless, we do have folks that, that choose to go without an attorney, and I handle a lot of pro se folks. And oftentimes I'll have folks come in and assume I know anything about them or their lives or their children, and I ultimately, or they'll come in and they'll say, well, all you have to do is call so-and-so, or he'll know about me, or he'll know the DCF worker that was at my house knows what happened, or here's the police report. And obviously we have evidence rules, and if somebody objects to a police report coming in, I would sustain it on hearsay grounds. But please, as I tell my pro se litigants, I don't know anything about you. I don't know how funny your child is or how sensitive he is. I don't know your work schedule. I don't know anything except for what you tell me in court. And if you just come in with testimony and the other side disagrees with your testimony factually, I have to pick who I believe. Who do I think is more credible? I think sometimes people don't understand the court's perspective in this and the limitations that we have.
Well, I'll tell you one of the things that is a recurring problem for people handling their own cases, and I'm sure you see this. They do their parenting plan in a very casual way. Mm-hmm. They don't really give a lot of thought to what they put in there. And what they don't realize is that when the court adopts that and they get divorced or they get whatever relief they want the first time, that agreement becomes pretty much set in stone. And what we see is them coming in afterwards and saying, one of the parents say, I don't really think I want the kid going to this school. I want him going to another school. But you look at the agreement, and it says they've agreed that both of them have to agree to the schools or whatever. And what is the standard that must be used when somebody wants to change the parenting plan? And we see a lot of that. What's the standard that the law requires for you to make a change in a parenting plan that's already been approved once by the court?
Okay. Well, at a final hearing, I'll just start with that. At a final hearing, as a magistrate, my standard is what is in the best interest of the child. And as Mr. Sobel indicated, there are a number of statutory factors that we have to consider in coming up with what we believe, based on what's been presented, is in the best interest of the child. Once it becomes final, the courts and the law sees that as final, and they don't like changing it every now and again unless certain statute or legal criteria are met. And the criteria that courts must follow once it's final is whether there's been a substantial material unanticipated change in circumstances, which is a very difficult standard to meet. And whoever's asking that the parenting plan or whatever needs to be changed has the burden of proving that there's been a substantial material and unanticipated change of circumstances. And assuming they've proven that, then we still have to go back to, again, what's in the best interest of the child.
Knowing this issue was going to come up, I took a quotation out of a case, which I really want to impress on our viewers, because they think that there's a change in circumstance that automatically is going to change their parenting plan arrangement. Here's what the quote is directly from the case. The person seeking modification of custody must show both the circumstances have substantially or materially changed since the original custody determination and that the child's best interests justify changing custody. Furthermore, the substantial change must be one that was not reasonably contemplated at the time of the original judgment. And we've had cases where the parents knew that one of the parents was going to relocate, was going to move out of state or out of county, yet they set their parenting plan up as if that parent was going to be there forever. And those are nightmares because they come into change, and guess what? The question is, did you know when you signed this that you were going to relocate? Yes. Well, guess what? We can't change this because you have not shown that substantial material change that was unanticipated. Have you had those cases?
I have absolutely had those cases, and I've had situations where I've had folks come in and say, well, my son is now 16 and he needs his father more in his life. Everybody knew at the time the child was 5 that eventually he or she would be 16 years old. So that is not an unanticipated change of circumstances.
And it comes as a shock, probably to both parents, that it's such a high standard. And the cases where a judge has not followed that, they get reversed almost automatically by the higher courts because you haven't shown your substantial change. And that's something that I really hope our audience can pay attention to because it's that important. Now, let's talk about the statutory factors that the legislature says that magistrates and judges are supposed to consider when there is a contested case in regarding parenting time and shared parental responsibility or time sharing. Now there's 20 of these, if you count the last one, which is just basically anything else that's important, but I guess basically 19 factors. We can't go into all those today, but Magistrate Inman, what would you say are the ones that you really think are determinative in many of your cases?
Well, and let me just start out by saying these factors apply to any dissolution cases or paternity cases. So any case that involves establishing time sharing for a child. As you said, there's about 20. There are a lot, and we do have to consider each and every one. In my experience, I find that's, and obviously every case is different, so I certainly don't want to say in every single case these are the most important. Because what could be the most important in one case could be the kitchen sink one that you just mentioned, the one that something that's not included in the statutory criteria. But what I would tend to, in a lot of cases, to find that is very important is the history of the parenting responsibilities of these parties and this child. And to me, that goes to continuing and creating a stable environment for a child that's going through turmoil in their life, with their parents being in warfare, I think is how you described it earlier. So the history of the parental responsibilities and if that's going to continue in the future. And so that could include third parties. Do we have grandparents, for example, that are providing child care or that are assisting in parental responsibilities? And so for me, the most important thing is maintaining stability and continuity for the child as long as the child is thriving. And so any factor that will go into that is, for me, very important.
If I may, just that catch-all term, factor T.
Yeah.
From a psychological standpoint, as a clinical psychologist, when we're asked to evaluate, we're very thankful that's there because we feel we can then impart whatever specific information that's related to the needs of that family and could help the trier of fact.
I think from my standpoint too, one of the things that judges and magistrates look for is which parent is going to be most likely to foster the continuing and close relationship between the children. A lot of times the parents have such hostility amongst themselves that one parent will do whatever he or she can do to keep that kid away from the other parent. Now sometimes there's good reason for that, but in many cases there is no good reason except that hostility. So what they're doing is putting themselves above the needs of the children. And when judges or magistrates see a situation where a parent is holding that child closely to them and not allowing the other parent to be involved with their lives, and there's no legitimate reason for that, that's a tip-off. You probably see that, Dr. Broder, don't you, sometimes, where you see that factor coming into play where you have somebody who is just excluding the other parent without really good reason.
Yeah, I always follow my own acronym for that is CRUD, C-R-D, for C for communication. What's the quality of communication between the parents? R is the relationship, which is the thing that you're referring to. To what extent is mom or dad allowing and facilitating to foster that ongoing relationship between parent and child, or children, as the case may be? And the D for development. To what extent do the parents recognize, acknowledge, and appreciate what the developmental needs of their child are and how they are going to change over time from preschool to elementary school to middle school, et cetera?
In trying to assist families getting ready to resolve the things directly with each other, or in preparing to persuade the magistrate in court later, we usually encourage them from the first time they meet with us, if they're already separated, to start texting messages to their spouses, giving them updates about the children, taking photographs of the children when they're doing unique or just photo-worthy things to keep the other parent up about the child. One, it's often responded to and liked by the other parent. helps them to resolve the issues, helps bring them together because they both have knowledge of what's going on. We also tell them, let the other parent have the school information, even though they can go get it themselves. If you get information from the school, let them know right away, including, oh, good report card. You might want to call our child and congratulate them. We find that not only does it help bring families together, but when it doesn't, it gives evidence for the magistrate to go ahead and have on the record and make a part of her decision that our client is encouraging and facilitating the relationship with the other parent.
And one of the things that I think is indicative of which parent is going to deserve more time is how willing is that parent to sacrifice their own personal situation for the children. I mean, those of us who have been parents know you have to make sacrifices for your children. And those that are very selfish and will, they'll say, well, the child's going to stay with grandma for 2 weeks in the summer, and you want that child to have a relationship with grandparents, but you also want them to have a relationship with the parent. And some of the things that we've seen in court where a parent will come in and say, I want to have more time share than the other parent without regard to the age of the child, because younger children have a different situation than older children. And I had them question on such things as, all right, what does your daughter like to read? What's a favorite book that she's read lately? Who are her friends? What are her favorite toys? What does she like to talk to you about? How does she feel about going to the doctor? And sometimes these people don't have any idea. And one parent does, the other one doesn't really. And it can be a pretty clear fault line as to who should have the most time with that child, because they're already doing it and they're already nurturing. But we do want to foster that situation between both parents. Magistrate Inman, do you have a talk that you give to the parents about their responsibilities as being a parent, or what they need to do with the parenting plans?
I do. And actually, before I answer that, I want to note that the legislature has put in the law that it's the public policy of the state that a child have frequent and continuing contact with both parents. So it's in the law that it's the public policy of our state. And yes, I do. Especially when I have, obviously if I have parties with attorneys, I won't do this, but when I have pro se litigants in front of me, and they have come, say for example, they've come to an agreed to parenting plan, I will go through it with them and explain to them what all of this means, not necessarily what it means or giving advice, but saying, this is what you're agreeing to. You're agreeing that mom is going to be the enrolling parent, right? And I will go through it, all of it with them to make sure that they're understanding what they're entering into and what their responsibilities will be, at least as far as the court is concerned, what's going to be enforceable.
Do you also look to see which parent would be most flexible in adjusting to changes that happen at the last minute? I mean, there are some parents who are so rigid. They say, I have this parenting plan, and by golly, we're going to stick to it, to the letter. But things happen. I mean, particularly this time of year, we're having graduations in school, and there may be things going on the child wants to do. Maybe there's a party he or she wants to go. Well, guess what? That's on one parent's schedule. So the parent who has the child on that weekend or that day says, you're not going to the party. You're going to come because I have it in my agreement here, and I don't care what you want to do. I think it's good that you stay with me and not go to the party. Well, those are parental decisions, but really, how flexible is that being for the child? And there may be instances where that's a good thing, but again, the goal is the best interest of the child, and which parent is really going to try to do what's best in that kid's best interest. Ed, the cases you've had that have been contested, what sort of problems do you see parents, or mistakes that you see parents making, either your clients or the others?
Well, what I had mentioned before is not encouraging and facilitating the relationship between the child and the other parent. That, I think, is the crux of persuading the magistrate when we're in court for whatever we're asking her to put into the parenting plan. And another big mistake, and it's often with well-meaning family members, is exposing the children to other people in the family who do not get this co-parenting, do not get the need for the child to have a good relationship with the other parent. We will often uncover text messages in getting ready for the hearings that will have things that should not be text to a child.
Right.
And you can't defend that. The magistrate can see it in court. It was text to the child, and definitely Dr. Broder, I shouldn't say definitely, he would let us know what kind of detrimental effect that has on the child.
And I think that's a good segue, Doctor. We'll turn to you now. Now, you're one of the psychologists that courts often appoint to the most difficult cases. So you see the most volatile of these situations where the kids are caught in the middle. The poor kids are listening to all this from both sides. There's this thing called parental alienation, where one parent's trying to poison the child against the other one. You've had cases involving children who have been abused physically or sexually. So just tell us, how do you approach the cases when you get one referred by the court?
Well, one of the first things I want to do is get to know the parents, and I'll meet with them individually and then try to see them with their child or children together so I can look at the nature of their interactions, and then see them again separately as individuals to talk about what happened when they were seen with their child. But the overall process is basically 4 different categories. One is the complete assessment of the parent, because we have to check for some of those other categories that
you work on the same factors that the magistrates work
absolutely,
with.
Absolutely, sir.
And by the way, let me just say, that's Florida Statute 61.13, subparagraph 3. I just mentioned that because you can go online, Google it, and look for yourself about those 20 factors.
Correct.
If anybody in the audience is interested. I'm sorry to interrupt. Go ahead.
Well, I was just going to say, because you need to assess the overall psychological functioning or mental status, emotional state of each parent, because you have to look for, is there any history of any kind of domestic violence, substance abuse, or mental illness. But you also want to get a kind of what we refer to as a psychosocial history. What is the background? So some of the questions that we asked here and that are discussed in terms of who's been doing the parenting and how things have worked under that arrangement. The second category is getting to know what the developmental needs of the children. Are we dealing with a special needs child, or have there been is this a kind of a mixed bag in terms of like a young child who might have been a mistake, and there's older siblings that are not involved. So there's all sorts of different family constellations that we have to look at. Third factor is you want to do a home visit. I always like to include the home side visit, because you could just learn a lot more about how a family functions and what's really happening, based in terms of, from a nutritional standpoint, what kind of snacks are being provided, what kind of routine they have with their homework. You mentioned about the toys and the books, so it's significant to see what's available. If there's a care for a pet, et cetera, you see what kind of responsibilities taking place. And the fourth category is what we refer to as collateral context. What other information, so it's not just my opinion, but I'm relying on perhaps reports from the teachers, the pediatrician, even extended family members, perhaps an employer. So there's all sorts of records you can accumulate to help formulate an opinion, because my job as a psychologist, or anyone in my shoes, is to inform the magistrate or the judge, as the case may be, so you have that much more information to make a determination as to what would be the best parenting plan.
So that's referred to as a social investigation?
Correct.
And so you look at those same 20 factors or so. Let's talk about the differences in the need for the parent to have contact with the child given different ages. Let's start with the newborns, or the say 0 to 5, basically preschool. What are you looking for with the parents on that, and how would your recommendation differ based on the age of a very, very young child?
Well, excellent question, because a lot of people think, okay, if this is our parenting plan, therefore that's our parenting plan, and we're stuck with that until they're 18. And Magistrate, I mean, when I were talking about this earlier in anticipation of our talk today, because In that early stages, it might be more heavily weighted towards the mother, particularly if the mom's breastfeeding. We're not going to look for a 50-50 arrangement with mom, worrying about pumping the breast milk and supplying that. So we're going to have that arrangement. But I think the case we were talking about, we have a 3-year-old boy. We might have a certain, maybe it's a 60-40 like Mr. Sobel presented. But when that boy is now entering middle school, in that early stage of adolescence, need his father in his life a lot more. So we want to have the flexibility. Here again, that's a key word, one of the factors. We want to look at the flexibility for the parents to recognize, acknowledge, and appreciate there are developmental changes. So we might have to adjust the parenting plan later on down the line.
Magistrate Inman, when you have one of these cases contested, and you have to do the parenting plan because they won't do it, how do you look at it from different ages? For example, a 15-year-old kid contact with a parent versus a 6-year-old?
That is absolutely something that I take into consideration. There are, in our circuit, there have been previous guidelines that have been issued about certain age groups, and just being a parent myself, I understand myself the different developmental ages and or stages, I'm sorry, and having further education through either legal education or going to family-oriented type of education through psychologists, or learning different stages and what's important for each stage. Now, if we're developing a parenting plan when the child is 5, what do we do when the child is now 16 and has different needs? And so one thing that I've asked some of my litigants is whether they're willing to modify for future purposes the statutory standard of substantial change in circumstances to best interest of the child. If they're willing to waive that, then that helps later on if there are changes. The other item I've considered is doing graduated time-sharing schedules, although it's hard to predict what a child is going to need at age 13. So obviously if the parties are able to come to an agreement to modify because the 13-year-old just doesn't want to do that time-sharing schedule anymore, then they're free to do that.
I think one of the key factors, getting back to the original question, like as psychologists, we look from 0 to 3, and then 4 to 5 is kind of a separate preschool category, and then we have the early stage of elementary school and the later stage. And at each stage, there are different kind of physical needs that the child has. Again, let's look at 0 to 3. We're looking at the physical needs, so it's all about the infant/toddler. So there's a lot more nurturing involved, a lot less need for socialization. But then the socialization need slowly starts to increase at age 4 and 5 when we look at a preschool situation. So I like to try to do my assessment on children based upon the 5 different developmental domains in terms of speech and language skills, socialization, because socialization is the precursor to personality development. Then we have their physical, both in terms of fine motor and gross motor coordination skills and their exposure to manipulate their toys and interact that way. Their cognitive development, of course, is very important, and then something we call ADL, activities of daily living. Just is the child able to self-soothe? Are they receptive to the toilet training process? And then getting older, are they able to know that they could help mommy take the plate to the table, that kind of thing. So there are all these stages, and then obviously those tasks become that much more involved as the child gets older. So we're looking, once again, what are the developmental needs of the child, and there are different needs at each stage of development.
How do you handle the situation where you have both parents fairly rigid in how they want the child to behave or their schedule in their home? In other words, let's say you have a 60-40 arrangement, and the mother wants the baby or the child, let's say it's a 10-year-old child, to go to bed at 9 o'clock, and dad doesn't care, stay up to midnight, and they go back and forth between these homes. Maybe one parent is very good about homework. The other one doesn't really care about homework. You can do it or not. You got the good cop, bad cop situation, good parent, then you got one that's, that's pretty strict, and you got one that says, do whatever you want to do. How do you address those issues, Dr. Broder? What's a good way to address it?
Well, it depends on which hat I'm wearing. If I'm the parenting plan facilitator, I could take more of a kind of a psychoeducational approach and work with the parents and try to educate them. If we have this, like you talked about, the 2 different bedtimes, So that 10-year-old, by the time they're 13-year-old, they're going to think they can get away with whatever they want. And so we're only creating problems, I try to tell the parents, by not getting on the same page. Because the research is pretty clear. If the child has, whether they're 5, 10, or 15, if they know what the routine is, if they know what the expectations are from the parents and that there are certain consequences, we know that's one of the things that's really going to help them in their development. And one of the things that causes such divisiveness is when there's this kind of tug of war and the parents don't get on the same page with their routine or their schedules or even their disciplinary practices. So in that role, I can take a kind of a psychoeducational approach. If I'm just in the evaluator, it's my job to inform the magistrate by explaining this is happening in mom's house, this is happening in dad's house, and therefore my whole section of my report would have a list of recommendations, and I would try to, the best of my ability, to advise the court that I think this is what should be addressed.
Ed, let me ask you about, have you had any contact or experience with parenting coordinators?
Yes.
Tell us about what those are.
Well, there are individuals that are used in what we call very dysfunctional cases. It's where the parents are not putting the children's needs in front of their own, where the parents are not encouraging and facilitating a relationship between the children and the other parent. It comes with a severe financial consequence because these people are not inexpensive. What these individuals will do, they'll be ordered by the court, there'll be an order setting forth the parameters of what they'll be doing for the parties, and the parties will generally be paying $150 to $250 an hour, maybe more for somebody like the doctor over here. And they sit down with these individuals and hash out their various controversies on a daily, weekly, monthly basis instead of working it out themselves. The professionals are great and they do a great job, but they're very expensive. And it comes down to something that we feel is very important in family law, and that people maintain their self-determination. Instead of giving it to yourself or to the magistrate or any other decision maker who, one judge used to describe it, it's like I'm getting a bunch of snapshots and then I have to decide these children's lives based on these snapshots. Instead of that, the parents who know the children should be able to determine what is best for the children, should be able to work these things out together and decide it themselves. That is self-determination, and it is almost always so much better from the children than having a stranger, yourselves, on behalf of the state of Florida, dictate to them how the rest of their lives are going to be in terms of raising these children.
And if I may add to that with the parent coordination, sorry.
It's okay.
You do that, don't you?
Yes,
Don't you
sir.
do some of that?
Yes, sir. And for the record, my fees aren't as high as you might anticipate. But I think the big factor is we have people who have divorced, and it's rare that I've met the people that say, oh, honey, I really did love you, but it's too bad it didn't work out, and now we can just go on being friends and talk. That ain't happening in my world. So all the shoulds that you mentioned, that would be nice. I find the parent coordination is a great avenue to allow these parties who are now divorced but still have very, very strong residual feelings. Many times those are feelings of anger and regret and remorse and guilt, perhaps. But the parent coordinator's job is to get them to communicate about the tangible stuff that's going to affect the children. So, for example, I'll meet with parties 3 times a year, right before the summer schedule, make sure they're on board and make sure summer's good. You know, the start of school, make sure the school year, around the Christmas holiday or holiday time, spring break, whatever. So we make sure those periods go smoothly.
And
so,
Magistrate Inman, you've had experience with them.
I have, and actually, I was as Mr. Sobel was talking, I'm thinking to myself, I give this speech to pro se people all the time. Do you really want a perfect stranger to your lives making this decision for you? Or would you like to try mediation and try to work this out between themselves? It's something that hasn't been discussed yet, but mediation is used quite frequently in
Let's
family.
talk about mediation. Tell us, what is that?
Well, mediation-
Well, he's a mediator, so
Okay.
let Ed do
Yeah.
it.
Mediation is a process where the people keep their self-determination and work out the issues of the parental decision-making and time-sharing themselves. The mediators are very good in our community, And I've never kept records, but I would say that since mediation started, the number of cases settling has greatly increased. I would say that it is over 90% at this point. And it's because the mediator, usually do it by separating the parties into 2 separate rooms and going back and forth between the rooms, helping them work on the settlement. They take the emotion out of it. The response in one room to a suggestion from the other room might be over my dead body, but when the mediator goes back in, the communication is, they didn't go for that, but they suggest this. The other thing, when the mediator is going back and forth between the rooms, he or she often sees the settlement long before the parties get there because they hear what's important in both rooms, and they're able usually to bring the parties together on first or common ground, and then addressing what the concerns are behind the needs and meeting each party's goal to do the settlement. It's a very successful process. I would encourage people to get into it as soon as possible when they know they're going to be in a child custody controversy.
And what we need to let them know too is that this is a neutral party. This is somebody who doesn't know much about any of this except what's brought into the mediation, and it's confidential. Nothing that's talked about or disclosed in that mediation conference is public. Now, if they work out a mediation agreement, like a parenting plan, and we do a lot of mediation with parenting plans because that takes a lot of work. It's nothing you can do like in a half an hour. So it takes time to work through it. And the 12th Judicial Circuit has mediators that work inexpensively for people that don't have a lot of money. I think there's a you may know
it's $60 to $120 depending on their incomes. I believe
$50 and $100 cut off.
$60. I think if their combined incomes are under $50,000, and I think if they're between $50,000 and $100,000, it's $120. And the circuit mediators are excellent.
And Magistrate Inman, how would a person get access to one of those mediators to help with a parenting plan?
Well, we do, at least with my pro se folks, if they don't know oftentimes that this service is available, I'll ask them if this is something they're interested in trying. If yes, then I'll get a judge to sign an order of referral to mediation. Folks with attorneys usually file motions for referral to mediation, and then they get that order from the court.
Well, we don't have a whole lot of time left here, but there is one thing I want to mention, which is our guardian ad litem program in family law cases. We also have guardians ad litem in dependency cases when a child is removed by the Department of Children and Families at a shelter hearing and is put with foster parents or relatives. That's not what I'm talking about. We have a number of attorneys who have been specially trained who will work for free in high conflict cases to act as the eyes and the ears of the court, to go investigate what's going on in these families and to make a report back to the court. Because typically we only have one side saying one thing, the other side saying something else, and it's very valuable for us to have the insights and the recommendations from these neutral parties who do this work basically free as part of their public service as members of the bar. We're very fortunate to have that. So I'm going to ask each of you to anything, closing comments you'd like to make about anything that you think that we've covered needs to be emphasized, or anything else that you think our audience would be interested in. Mr. Sobel, I'll start with you.
I would advise people that if they know they're heading towards a child custody conflict, to get advice from an attorney as soon as possible. It will help them from doing things that may be harmful for their children, and also the case itself. I'd also suggest if they have access to a mental health person, to get advice from them also.
Magistrate Inman.
Well, the one thing I certainly want to say is that I would always find it advisable for people to try to work these issues out themselves. Again, they know their lives, their child far better than I would. But if they can't come to an agreement and you end up coming before a magistrate or a judge, be prepared to bring your evidence with you to support your position that your parenting plan is in the best interest of your child. Just be prepared to do that, because that is what is going to what the judge is going to consider, and is going to have to consider under the law. One other thing I just wanted to add is that there's another website that I'm not so sure Judge Hayworth brought up that I think is very valuable, and that's the 12th Judicial Circuit's website. The 12th Judicial Circuit has a number of parenting plans that you can review. They were referenced by Mr. Sobel, our basic, our long-distance parenting plan, safety-focused and highly structured, and that it's got instructions for all of them, and so certainly that's a valuable resource as well.
Thank you for that. Dr. Broder.
Yes, I would say that Mr. Sobel was right on the money. I think there used to be something referred to as divorce counseling, and that has been overlooked because if people, in anticipation of getting divorced, if you came in and spoke to a psychologist, just perhaps for your own personal therapy, but more importantly, just a few consultations to get a better understanding of what to expect and how it's going to affect your children. And because the second part of the answer is that what I have found is that the parents are more concerned with getting the plan that they like, and it's not necessarily what's best for the children. And if they go through this divorce counseling, they get a better understanding of what the developmental needs are of their family constellation, and then they're more prepared to handle that.
All right, great comments from all of you. I want to add one additional resource, and this is something that would be very useful for anybody that's interested in the law and these factors we've talked about, and it's a free resource. There's something called the Association of Family Conciliation Courts, and there's a Florida chapter of that. I'm going to ask that METV make that graphic on the screen for you at some point here, because they have a book that's called it's a bench and bar book. It's for lawyers and judges, called Empirically Based Parenting Plans, and it has a lot of useful information that you'll find there. Well, that's all we have time for today. I'd like to thank Ed Sobel and Magistrate Renee Inman, Dr. Brad Broder, for sharing your knowledge and expertise on a difficult subject. Thank you also for making METV, for making this show possible. Deciding on how much time a child gets to spend with each parent and how parenting duties are allocated are some of the most perplexing challenges faced by lawyers, psychologists, and judges in family law cases. I hope the discussion we've had today will give the audience some insight into how those decisions are made, and that whether by agreement of the parties or by the decision of a judicial officer, the arrangement is truly in the best interest of the children. Thank you for watching.